This is a video that contains the continuation of our January the 22nd class, which involved discussing codes of conduct impacting CPAs. So let's take a look at the first slide here, and this is a little bit of a review, but it helps put things within context. So here we see a summary of the AICPA Professional Code of Conduct. And if you look at this, you can see that it's actually broken into literally 4 parts. There's a part that says all these codes of conduct are applicable to all members, whether they're in public practice, if they're in business, or if they're in other pursuits. The second area then, where it says part 1, involves basically the code of conduct that is applicable to members in public practice. The second part then of the code of conduct are the parts of the code of conduct that are applicable to members of business. The third part of the code of conduct includes all the parts where they're applicable to members in an other type of status. In other words, you can't fit them under public practice or under business. And you'll remember we discussed this in our class, saying that the professional code of conduct is broken up into 3 parts: public practice, business, and other members. So now let's take a look at basically the overall code of conduct, whether or not it's applicable to all members or members in public practice or members in business. We're going to go over the code of conduct in general and try to understand the major portions. Okay, the first area in the code of conduct is the independence rule. And the independence rule says a member in public practice shall be independent in the performance of professional services as required by standards promulgated by bodies designated by the council. Now, what this is really saying is that a CPA, when they perform their job, they perform their function, needs to be independent in performing their function. Now, as you can imagine, there are a number of individuals who are involved in an audit or in a test function. And this became a source of confusion because not everyone needs to necessarily be independent as described under the independence rule. So the AICPA provided a definition, and they said that the independence rule pertains to what is called covered members. Now let's take a look at what that word covered members means. A covered member includes all the individuals who are participating in an engagement. Also, an individual in a position to influence the engagement, even though they're not part of the engagement. Number 3, a partner or a manager in a public accounting firm, obviously, who provides at least 10 hours of non-attest services to the client. As an example, if a tax partner provided 30 hours of tax services, which are non-attest, to an attest client, that particular partner, or could be manager, would basically would be considered a covered member. Now, a covered member also includes a partner in the office where the engagement partner practices. A covered member also includes the firm's benefit plan, especially if the benefit plan owns investments in the an investment in the test client, either direct or indirect. A covered member includes an entity that can be controlled by any person who's considered a member. And covered members also include close family members, meaning parents, siblings, non-dependent children. A covered member also includes immediate family members, including the spouse or a spousal equivalent, or dependents, whether or not they're actually related. Now, what can a covered member basically, a covered member cannot do certain things? And here's a fairly, I wouldn't say comprehensive, but a listing of the major areas. First of all, a covered member cannot have a direct financial interest in a client. Makes pretty much sense. You shouldn't have an investment in your client. But a covered member also cannot have a material indirect financial interest in a client, meaning that a good example of that is if the covered member is a shareholder in an investment fund that has a material interest or material investment in an attest client. A covered member cannot be a trustee or administrator of an estate that has a direct or material indirect financial interest in a client. A covered member cannot have a joint investment with the client that is material to the covered member. As an example, let's assume that a partner who is a covered member audits ABC Company. The CEO of ABC Company owns an investment, let's say 50% interest in another investment, and the partner of the CPA firm owns the other 50% interest. In that case, the covered member cannot do that. That would affect their independence. A covered member cannot have a loan to or from a client or any officer of the client or any other individual owning more than 10% of the client. Then lastly, a covered member cannot participate on an attest engagement if he or she was formally employed by the client in a position to influence the current audit or act as an officer, director, promoter, underwriter, or trustee of a pension or profit sharing trust of a client. So these are items a covered member cannot be involved in. Now we get to the family side of things. A covered member's immediate family cannot have, just like the covered member, cannot have a direct financial interest in the client. A covered member's immediate family cannot have a material indirect financial interest in a client. Covered member's immediate family cannot have vested retirement benefits within a client. Okay, now we move to the next level of relatives, and it says a covered member's close relatives, as we defined in our previous slide, cannot have a key management level position with the client. Covered members' close relatives cannot have a material financial interest in a client that is known to the covered member. Also, covered member's close relatives cannot have a financial interest in a client that allows the relative to have significant influence in the client. And also, the covered member's close relative or relatives cannot be in a position to be able to influence the audit. Another area that can affect independence is the case where a partner or a professional employee associated with the client cannot be associated with the client as a director, officer, employee, promoter, underwriter, voting trustee, or trustee of a pension or profit sharing trust of the client. Okay, now number 7, question number 7 uh, is along these lines in terms of covered members, who's a covered member and who's not a covered member. I will tell you that on the CPA exam, if they talk about or if they address a code of ethics on exam questions, there's a higher probability they're going to be asking questions about who may be a covered member and what they can do and what they cannot do, things like that. So let's try this question here. We have a CPA firm called Pipper and Company. And Pipper and Company CPAs audits a client called Engulf and Devour Corporation. Aaron is the engagement partner, in other words, the engagement partner on behalf of Pipper and Company CPAs. Her office is located in the city of Timbuk 1. Now we're asked which of the following persons would not be considered a covered member under the circumstances. So we take a look, now we have 4 different instances. So go ahead and review these instances, stop the video, arrive at what you consider to be the correct answer, and then when you're ready, go ahead and restart the video for the appropriate answer. Okay, now we move on to the answer to number 7. And again, the question is, Pepper and Company audits Engulf and Devour Corporation. Aaron's the engagement partner and her office is in Timbuk 1. Which of the following would not be considered a covered member? And we take a look at A first, and the correct answer is B. We'll get to that in a minute, but we take a look at A. It says Steve is the manager of the attest team of Engulf and Devour, and his office is in Timbuktu. Even though his office is in Timbuktu, because he's one of the members of the attest team, he's considered a covered member. Let's take a look at C. Peter is a Pipper engagement partner for Engulf and Devour. Unbelievable. Okay, now let's look at question number 7. Pipper and Company CPAs audits Engulf and Devour Corporation. Aaron is the engagement partner, in other words, a partner who's in charge of the audit engagement for Engulf and Devour. Her office is located in the city of Timbuk 1. So which of the following persons would not be considered a covered member? So we're looking for the exception in this listing. So go ahead and analyze the question and the answers, stop the video, and when you're ready with the answer, with your analysis, go ahead and restart the video and review for the correct answer. Okay, now let's look at a multiple choice question, in this case question number 7. I should also mention that when there are questions regarding the AICPA Code of Conduct, the examiners like to spend time in questions regarding basically a member's independence, who is a covered member, what a member can do, what a covered member can do versus can't do. So this is a good representative question. Pipper and Company CPAs audit the Engulf and Devour Corporation. Aaron is the engagement partner, in other words, the partner who's actually in charge of the audit. Her office is located in the city of Timbuk 1. Now the question is, which of the following persons would not be considered a covered member? And you're given four different individuals. You have to pick out the member that would probably not be considered to be a covered member. Go ahead and analyze the question, analyze the answers, stop the video, and when you are ready with your answer, go ahead and restart the video and view the answer. Okay, number 7. Pipper and Company audits Engulf and Devour Corporation, and Aaron's the engagement partner on the audit. Her office is in Timbuk 1. Which of the following would not be considered a covered member? So let's go over the individual answers. Oh, by the way, the correct answer is B. Samantha, who is a Pipper tax partner, provided 5 hours of tax services. So let's understand why A, C, and D are definitely covered partners. Okay, we take a look at A. And we say here, Steve is a manager of the attest team of Engulf and Devour. So Steve is a manager of the audit team for Engulf and Devour. And if you remember, that would include all individuals. He would be one of those all individuals who are participating in the engagement itself. Even those offices in Timbuk 2, it doesn't matter. He's participating on the engagement. Okay, let's take a look at C. Peter, who's a partner of Pipper and Company, is not involved with the audit in Engulf and Devour. So he has nothing to do with the audit. So he's not participating on the engagement. But his office is located in Timbuk 1. And that means Peter would be a covered partner, because what that means is he would be a partner in the office where the engagement partner practices, because the engagement partner is also from Timbuk 1. Okay, now let's take a look at D, where Ann is a partner of Pipper and Company, and she's located in Timbuk 1. Now, it doesn't say whether or not Ann is in the engagement or not, but she is in the office where the engagement partner exists. So in this case, she would be considered to be a covered member. So by the process of elimination, we would pick B, about Samantha. Now, also the reason that Samantha is not a covered partner is she provided 5 hours of tax service, which is non-attest service, to Engulf and Devour during the audit year. Now, again, and also her office is in Timbuk 2. So even though she's an audit partner, her office is in Timbuk 2. So right away, she wouldn't be a covered partner under that criteria. Also, she did work on some work for Engulf and Devour, but the rules say that you have to have at least 10 hours of non-attest type services. So in this case, she only performed 5 hours. So in this case, Samantha would be a non-covered member. Okay, now let's take a look at prohibited relationships. And again, these double back on the areas where we have covered, again, with covered partners or covered in members. A prohibited financial relationship, and we've talked about this in the individual rules, but we're going to define it here. Basically, prohibited financial relationships can happen if it's a direct relationship. And what that means is a financial interest that is owned directly by an individual or entity, or is under the control of the individual or entity. So that's a direct financial relationship. But you can also have what we called, we talked about this earlier, material indirect financial relationship. And that means if the covered member has a financial interest in an entity that is somehow associated with an attest entity, for example, an investment in the mutual fund that owns the entity's stock, That would be a material indirect. That could be a material indirect interest, and if the member is a covered member at that point in time, then that would be uh, violate, or that would jeopardize the independence of the auditor. Prohibited business relationships, and again, this is a drill down on some of the covered partner rules. The independence of a CPA is impaired if a CPA performs a managerial or other significant role for an entity's organization during the time period covered by an audit. In other words, you can't be independent and be a manager or participate in the management of the organization you're auditing. Also, another prohibited business relationship is a partner or professional employee leaves a firm and is subsequently employed by or associated with that entity in a key position. Again, that would jeopardize the independence of the CPA firm. Okay, continuing on with prohibited relationships. Now we get into the family side. Family relationships is a close relative that has a financial interest in the entity that is material to the close relative, and the CPA participating in the engagement is aware of the interest. We talked about this before under family relationships, but I've expanded on it a little bit more here. Also, in addition to that, an individual participating in the engagement, the audit engagement, has a close relative who could exercise significant influence over the financial or accounting policies of the entity. Again, that's a prohibited relationship. And again, I have the definition of close relatives include non-dependent children, brothers, sisters, parents, grandparents, parents-in-law, and their respective spouses. Okay, let's take a look now at number 8. Number 8 is, in which of the following circumstances would a CPA who audits ACME, a financial institution, lack independence? So again, we have 4 situations, and we have to find the one situation where the relationship that we see there would cause the covered member to basically be considered to lose their independence. So go ahead, take a look at your answers, and stop the video. When you're ready, go ahead, restart the video, and take a look at the correct answer. Okay. Number 8, our answer, in which of the following circumstances would a CPA who audits ACME, a financial institution, lack independence? And in this case, the answer is B. The CPA has invested in a managed investment fund, and the fund has a material interest in the audit client, in ACME. We take a look at the items that we didn't select. We take a look at A, and it says the CPA and ACME's president or CEO, if you will, are both on the board of directors of XYZ, which is a non-client entity. So both these members are providing fiduciary type of assistance to XYZ Corporation on the board of directors, but this doesn't impair the CPA's independence because there is no relationship in this case other than both being on separate members on a board. If we take a look at C, the CPA has an automobile loan from ACME, and that wouldn't necessarily be unusual because it appears to be some form of financial institution. But the CPA has an automobile loan from ACME, and the loan is collateralized by the automobile. So in this case, it doesn't look like it was a gift or anything else. Basically, the CPA borrowed money, and the loan, in effect, the auto title is owned by ACME until the loan is paid off. D, the CPA reduced Acme's usual audit fee by 40% prior to the audit because Acme's financial condition was unfavorable. Again, this wouldn't be a violation of the code of conduct. CPA can pretty much set their own fees for an audit, and if they, for whatever reason, are willing to take a hit, they can do that. Now, there is a case we'll find out a little bit later on where if a CPA is bidding for an audit, it's against the code of ethics to basically knowingly underbid. In other words, knowingly get into an audit where you you're going to lose money. Basically, in effect, like lowballing type of. But that is not the case in this case. Okay. Number 9, this is called the effect of actual or threatened litigation. Okay, a CPA's independence is impaired if, okay, there's commencement of litigation by management of the audited audited entity alleging deficiencies in audit work for the entity. Also, independence can be impaired with if there's an expressed intention by management to commence litigation against the CPA, alleging deficiencies in audit, or if the CPA concluded that it is probable such a claim is going to be filed by the client. That would impair independence. Thirdly, then, the commencement of litigation by the CPA against the client alleging management fraud or deceit. That will also impair independence. Now we're going to talk a few minutes about the Securities and Exchange Commission and the PCAOB. Now remember, the PCAOB essentially reports to the SEC because the SEC is in charge of appointing the members, the governing body of the PCAOB to the PCAOB. So here's what I say: SEC and PCAOB independence rules. And what they say is an auditor's independence depends on the auditors both having the proper mental state and also passing the appearance test. And here we talk about the mental state being independence in fact. In other words, the CPA has to have a mental state of objectivity and a lack of bias. Also, another very interesting rule, and this can be a little tough sometimes, the CPA also has to have independence in appearance. That basically, and what does that really mean in terms of appearance? Because that can almost mean anything. If a CPA shakes hands with the client, does that make them independent? Does that impair independence? Well, we go back then, the SEC goes to the reasonable person test. It says it depends on whether a reasonable investor with knowledge of all of the relevant facts and circumstances can conclude that the auditor is not capable of exercising objective and impartial judgment. If a knowledgeable investor sees a CEO and the CPA shaking hands, it's probably not going to raise them to the level where they're basically suspicious of that the auditor cannot maintain their independence. On the other hand, if the CEO of a company flies the audit team around the world for dinner in Germany, then in India, then in Singapore, and then on the west coast of the United States and back to their home, in that particular case, there would be a question whether, the appearance, there would be an impairment of independence, because I think a reasonable investor, knowing about the facts and so forth, would have kind of an issue with something like that. Now, the SEC and the PCAOB, and also pretty much the AICPA, for the most part, basically have what they call independence rules for audits of public companies, in terms of there are certain services that a CPA firm cannot cannot perform for an attest client. Now, those would include bookkeeping services, actuarial services, broker and dealer type of services, financial information systems design and implementation, internal audit outsourcing services, legal services, appraisal or evaluation, management or human resources functions, or expert type of services. Many CPA firms perform these type of non-audit services as part of their in effect offerings of services, but these services cannot be offered, nor cannot be offered to attest clients. Now, that wouldn't stop the CPA firm possibly from offering these services to non-attest clients. But if you already have an attest client, the CPA firm cannot perform any of these type of non-audit services. So, number 9, according to the AICPA Code of Professional Conduct, which of the following actions will impair independence? And again, we have 4 actions. 3 out of the 4 will not impair independence, 1 will. So again, do your analysis, stop the video, and when you are ready, restart the video and answer the question. Okay, number 9, according to the AICPA Code of Professional Conduct, which of the following actions will impair independence? And we can see in this case the answer would be C, participating in the hiring or termination of a client's employees. And you can see this under the list of prohibited non-audit services for attest clients, where we have basically management functions or human resources. If we take a look at A, it says preparing a client financial statements based upon information in a trial balance. So the CPA firm, all they're doing is compiling information to basically prepare financial statements. They're making no management decisions. Also, the CPA firm, in this case, for B, would be processing payroll for a client's signature based upon the client's record keeping. So all the CPA is doing is providing a processing service. And D, assisting a client in drafting a stock offering document or memorandum. Okay, let's go on to the next item. And again, this is part of independence, SEC requirements. Okay, on an audit, engagement partners are limited to 5 consecutive years on the same public company. After that, they have to rotate off. Also, another rule is a 1 year, that we call a cooling off period, is required for employees in a financial reporting oversight role who previously worked with the CPA firm performing the audit. A third rule is a firm is not independent if an audit partner's compensation is based upon selling engagements to an attest client for services other than audit review and attest services. Okay, now let's go on. Now that we've worked with basically beaten the independence rule to death, literally, we're going to go on to another one of the rules in the AICPA Code of Conduct. And it's called the integrity and objectivity rule. Now, in the performance, as the rule says, in the performance of any professional service, a member, and again, a member means a member of the AICPA, shall maintain objectivity and integrity, shall be free of conflicts of interest, and shall not knowingly misrepresent facts or subordinate their judgment to others. Okay, and examples of violations would be the CPA makes or permits or directs another to make materially incorrect entries in a client's financial records. Okay, in other words, the CPA could make those entries and that would be a violation, or direct other people, such as a client, to basically create materially incorrect entries in the client's financial statements or records. Another violation is if the CPA fails to correct financial statements that are materially false or misleading when that member has such authority. And lastly, another violation is when the CPA signs or permits or directs another to sign a document containing materially false and misleading information. So these would be violations of the integrity and the objectivity rule. And again, when you read about these, if you have any sense of ethics, you can see why these are violations. Now, there's another rule called the General Standards Rule, and it says a member shall comply with the following standards and with any interpretation thereof by bodies designated by the council, including, basically, there's a requirement that we follow, or CPAs, the members follow professional standards and interpretations. In other words, follow the rules. Perform only those services that can be completed with professional competence. In other words, don't take on an audit that you knowingly cannot complete with professional competence. Thirdly, exercise due care. Do not be reckless. Also, adequately plan and supervise all the engagements, which again, when you think about that, that's just a reasonable organizational process. Also, lastly, obtain sufficient relevant data to afford a reasonable basis for all conclusions and recommendations. And remember, we talked about this in class, where the job of the CPA is to gather evidence to reach eventually their conclusion regarding the fairness of the information that has been presented in the financial statements. In other words, to reduce information risk to an acceptable level. And again, it says obtain sufficient and relevant data. So we just don't basically obtain just any type of data. We want to have data that directly helps us prove and support our opinion. Now let's talk about the compliance with standards rule. And it's written, a member who performs auditing, review, compilation, management consulting, tax, or other professional services shall comply with standards promulgated by the bodies as designated by the council. So this is a rule saying that the members of the AICPA have to recognize that there are certain technical bodies that create the standards to which the AICPA members should adhere. And I have a listing of those right here below the compliance with standards rule. As an example, the AICPA has designated the Auditing Standards Board of the AICPA and the Public Company Accounting Oversight Board, the PCAOB, as the technical bodies that create audit standards. In the case of the AICPA, it's statements on auditing standards, and again, those are auditing standards for non-publicly traded companies. In the case of the PCAOB, they create the auditing standards, PCAOB, for publicly traded companies. So these are the official standard setting bodies as designated by the AICPA. We also have a technical body called Management Consulting Services Executive Committee, or MCSEC. Now, this is also a committee of the AICPA, but the AICPA looks to this committee to set the standards on consulting services, so statements on standards for consulting services. Thirdly, we have another group called the Accounting and Review Services Committee, which is the ARSC, which is also part of the AICPA, and the AICPA has designated that technical body as creating the statements on standards for accounting and review services. Plus, we also have a combination of technical bodies: the Accounting Standards Board, the Management Consulting Services Executive Committee, and the Accounting and Review Services Committee, that are the technical bodies that create the statements on standards for attestation engagements. And lastly, the AICPA is designated the FASB, the Financial Accounting Standards Board, the GASB, the Governmental Accounting Standards Board, and the FASAC, and that's the Federal Accounting Standards Advisory Committee, for creating generally accepted accounting principles. And we talk about FASBs, GASBs, and the FASACs, statements and related interpretations. These are the financial reporting frameworks that create the generally accepted accounting principles. Let's go on now and take a look at what is called the Accounting Principles Rule. And again, this goes back to members of the AICPA. Okay, a member shall not express an opinion or state affirmatively that the financial statements or other financial data of any entity are presented in conformity with generally accepted accounting principles, or state that he or she is not aware of any material modifications that should be made to such statements or data in order for them to be in conformity with generally accepted accounting principles. If such statements or data contain any departure from an accounting principle promulgated by the bodies designated by the Council from our last slide to establish such principles that has a material effect on the statements or data taken as a whole. So what this is saying is basically a member is not to express an opinion that statements are fairly stated if they're not fairly stated in conformity with the applicable, in effect, financial reporting framework. Now, the Accounting Principles Rule also has an additional portion to it, and it does allow the I shouldn't say the member to have an out, but sometimes a financial situation doesn't fit neatly into the applicable financial reporting framework for a variety of reasons. It can even be, let's say, industry practice. So this next paragraph allows for that. It says, if, however, the statements or data contain such a departure, again from generally accepted accounting principles, and the member can demonstrate that due to unusual circumstances, the financial statements or data would have been otherwise been misleading, the member can comply with the rule by describing the departure, and that would be the departure from GAAP or the financial reporting framework, its approximate effects, if practicable, and the reasons why compliance with the principle, or in effect the framework, would result in a misleading statement. Let's take a look at another rule under the AICPA Code of Professional Conduct, and that's called the Confidential Client Information Rule. And this pertains to clients both past and present. Client information may not be disclosed or used without client consent. Now, there are exceptions to this particular rule, and the first one is the auditor's obligation, basically compliance with obligations under other rules of the AICPA Code of Conduct. So if other rules within the AICPA Code of Conduct require some form of disclosure of client information and the client claims that's confidential under the AICPA rules, the auditor may still be obligated to disclose it. Number two, the auditor needs to comply with a valid enforceable subpoena. Another exception of release of information without client consent is if the auditor is required to disclose that information because of applicable federal or state laws or government regulations. Another exception is if there's a client information will be disclosed in a review of a member's professional practice under the PCAOB, the AICPA, state society, or state board of accountancy, and that also includes peer reviews. Lastly, client information may be disclosed without client consent if it will preclude a member from initiating a complaint with or responding to any inquiry made by an authorized investigative body. You can't hide behind client confidentiality in certain circumstances. With that then, let's take a look at question number 10. To which group can a CPA provide audit documentation without being subpoenaed and without the client's consent? And let's add to that to make it a little bit clearer. To which group can a CPA provide confidential client information without being subpoenaed and without the client's consent? You're given a number of choices. Go ahead, stop the video, analyze your choices, and when you're ready, restart the video. Okay, the answer to number 10, to which group can a CPA provide audit documentation without being subpoenaed and without the client's consent? In this case, the answer is another CPA firm performing a peer review, and we could see that again under exceptions under the confidential client information rule. Here's one that's a little bit harder. A client has omitted a significant disclosure from the financial statements. Now, the auditors ask the client to include the information in the financial statements, but the client refuses and claims that that information is confidential, so it shouldn't be included in the financial statements. However, the auditor's kind of caught in a dilemma because the auditor's opinion is that information needs to be there to make the statements basically to ensure that the financial statements are fairly stated. So in this case, the position of the CPA should be that the information, and you're given 4 alternatives. Again, stop the video, analyze your alternatives, and when you're ready, go ahead and restart the video. Okay, the answer to number 11, again, a client has omitted a significant disclosure from the financial statements. The auditor has asked the client to include the information, but the client refuses and claims the information is confidential. The position of the CPA should be that the information, and the answer would be A, cannot be considered confidential if it is necessary to the completeness of the financial statements. And again, we see the exception to the confidential client information rule, where the auditor has to comply with the obligations under any other rules of the AICPA Code of Conduct. And this would be an issue under the accounting principles rule, where basically the member cannot express an opinion, an affirmative opinion on the financial statements, unless the statements have been presented in conformity with generally accepted accounting principle. There's no material modifications. That's not the case in number 11. Let's talk about the contingent fees rule. Okay, and basically a member shall not perform for a contingent fee any professional service for or receive such a fee from a client for whom the member or the member's firm performs, number one, an audit or review of a financial statement, or B, a compilation of financial statement expected to be used by a third party. And we'll understand a little bit later on there is a difference between audits, reviews, and compilations. And then C, an examination of prospective financial information, or prepare an original or amended tax return or claim for. Let's take a look at the acts discreditable to the profession rule. A member shall not commit an act that is discreditable to the profession. And I have a listing of a number of them that these include, but they're not limited to, acts discreditable, such as discrimination and harassment in employment practices. Another act would be solicitation or disclosure of CPA examination questions and answers. A third one would be failure to file a tax return or pay a tax liability. Number 4, negligence in the preparation of financial statements or records. Another act would be failure to follow requirements of government bodies, commissions, or other regulatory agencies. Number 6 would be disclosing confidential information obtained from employment or through volunteer activities. Another act that would be discreditable would be false, misleading, or deceptive acts in promoting or marketing professional services. Another discreditable rule or act would be improper use of the CPA credential. And the last two acts are kind of related, but the first one is failure to comply with records requests and also withholding client records. In other words, the records that are the property of the client, withholding client records upon the request of the client for their return. Now, I want to add here that auditors prepare, as part of their evidence gathering process, prepare a number of auditors' work papers. The auditors' work papers are their own property, and the auditor has the right to either provide those work papers, copies of those work papers, to the client, or can simply say, no, they're our property, we're not disclosing them to you. Now, that also then implies that if a client demands records or demands those records, again, those are the auditor's property, and the auditor doesn't have to release those. But if they are the client's property, the auditor has to release them upon their request. Okay, let's take a look at number 12 now. Which of the following actions by a CPA most likely violates a profession's ethical standards? And again, we're given 4 situations and we need to choose the correct one. Again, stop the video, analyze the answers, and when you're ready, go ahead and restart the video and review the answer. Okay, and number 12. Which of the following actions by a CPA most likely violates a profession's ethical standards? And in this case, the answer would be most likely C, retaining client records after the client has demanded their return. Okay, there's also rules of professional conduct regarding advertising and other forms of solicitation. And it says a member in public practice shall not seek to obtain clients by advertising or other forms of solicitation in a manner that is false, misleading, or deceptive. Solicitation by the use of coercion, overreaching, or harassing conduct is also prohibited. Now, some examples would include creating false or unjustifiable expectations of favorable results, such as we can guarantee you a refund on your tax return. The second example is implying an ability to influence any court, tribunal, regulatory agency, or similar body or an official. In other words, the CPA saying, look, we have the inside track on this. This guy's my golfing buddy or whatever, and we can get a ruling in your favor. Third, claiming that specific professional services in current or future periods will be performed for a stated fee, estimated fee, or fee range when it's likely at the time of that representation that such fees will be substantially increased, and the prospective entity is not advised of that likelihood. In other words, we call that, another word for that is called lowballing, and trying to get a particular job or project by understating the fees, knowing that later on those fees are going to have to be increased. Also then, the last item is making any other representations that would be likely to cause a reasonable person to be misunderstood or deceived. That's almost fraud. Okay, now also there's a rule on auditors receiving commissions and referral fees. Okay, first of all, contingent fees. Those fees based upon a particular finding or outcome, in other words a contingency, are not permitted for attest engagements. A fee is not considered contingent if that fee has been fixed by the court or it's based upon the hours worked or services provided. Obviously, that's a very objective way of developing a fee. It's not based upon necessarily an outcome. Now, contingent fees can be allowed for non-attest type of services, and that includes tax, consulting, and litigation support type of engagements. Auditors can receive commissions, receiving fees for which are basically receiving fees for recommending the products or services of clients or third parties, typically non-CPA parties. Now, these commissions are permitted for non-attest engagements as long as those commissions are disclosed to the party entering into that contract. They are prohibited for any type of attest engagements. Now, referral fees, in other words, receiving fees for recommending the services of CPAs, basically are permitted for any engagement if, again, they are disclosed to all parties. Form of organization and name rule. Okay, number one, a member may practice public accounting only in a form of organization permitted by law or regulation whose characteristics conform to the resolutions of the council. Now that basically means you can practice in basically any legal form of organization, whether it be a partnership, whether it be a limited liability company, uh, whatever is allowed by the whatever is allowed by the state. Now, a member shall not practice public accounting under a firm name that is misleading. Names of one or more past partners may be included in the firm name or successor organization. As an example, I can pretty much guarantee you Mr. Price and Mr. Waterhouse died a long time ago, but their name is still there under Price Waterhouse. A firm may not designate itself as members of the American Institute of Certified Public Accountants unless all of its CPA owners are members of the Institute. Now I believe we have one question number 13 on basically under this form of organization. Which of the following is required for a CPA firm to designate itself as members of the American Institute of Certified Public Accountants on its letterhead? Again, you're given 4 choices. Analyze your choices, arrive at an answer, and when you are stop, don't forget to stop your video, and when you're ready, restart the video for the answer. Okay, and the answer is 2. Which of the following is required for a CPA firm to designate itself as members of the American Institute of Certified Public Accountants on its letterhead? And the answer in this case is A. All of the owners, in effect the CPA owners, must be members. And with that, that is the end of our presentation, the extended presentation on our class of January the 22nd. And thank you for your time.